Sponsors. Are you a family caregiver? Are you caregiving for someone who can no longer take care of themselves? Are you overwhelmed? This is Caregiver Solutions Info with Marcia Teal. Marcia will be hosting an hour of true stories and information, tips and updates of the latest research and necessary information in the caregiving field, focusing on you, the family caregiver. An Alzheimer's disease and dementia care expert, Marcia has 15 years of hands-on experience at Arden Courts, a leader in assisted living dementia communities here in the U.S. Marcia covers everything you need to know as a family caregiver, especially if you care for a loved one with Alzheimer's disease or other related dementia or chronic illness. If you have a friend or relative that is also a family caregiver, call them now. They won't want to miss a minute. And let them know they can watch on caregiversolutions.info. And they can listen on WNN 1470 AM in South Florida or nationally on the iHeartRadio app. Now, sit back, relax, and learn from our host, Marcia Teal, as she brings information to you that may just be the caregiving solution you need.
Hi, everyone, and welcome to Caregiver Solutions Info Show. I'm so happy you could join us today. We have another wonderful show for you. We are actually live from Boca Raton, Florida. At least some of us are. My guests are in the studio in Boca Raton, and I'm actually broadcasting to you from Largo, Florida, where we have an Arden Courts memory care community. So I'm on location in Largo, visiting Arden Courts and bringing this show to you, broadcasting live, but we're a little bit separated. So it's actually the first time doing this new technology for me, so I hope it goes as well as it's supposed to, and I'm excited to try this, to bring this to you. If you're listening to us on local Florida radio, thank you for tuning in. If you're watching us on caregiversolutions.info, thank you for getting on your device and watching us live that way. This show is for caregivers and for people that want to learn more about caregiving and about dementia and Alzheimer's. So we're in our 2 years now. We've successfully actually had many, many shows every single week for 2 years, and I'm excited that we're continuing this program because it's proved to be so valuable to caregivers and professionals. So without further ado, I want to talk about what you need to know as a caregiver from a legal standpoint. There's not enough said about this to be prepared. And the big thing is for caregivers certainly need to be prepared in many, many ways. And one of those ways is by checking out what is required and what you'll need in the course of your caregiving for someone that you're taking care of, so that you can make everything a little bit easier and better and make sure that you get what you need. And today, to discuss all that and more, I have two wonderful guests in the studio. And joining me is from the law firm of Becker and Polyakoff, Heidi Freeman, elder law attorney, and Phil Rosen, probate attorney. Hi, guys. Are you there?
Hey, Marcia.
Hi, Marcia. Thanks for having us.
Oh, I'm so excited. I can see you, and you can see me, and this is all awesome, and everybody can hear us on the program. So I'm so excited. I'm not there in person with you, but this is fun, and I appreciate you coming into the studio so we can continue to do our show. So welcome, welcome, welcome. And the first thing I want to talk about is the elder law aspect. So I know that you are an expert because you're an elder law attorney. Heidi, tell me a little bit about what goes into being an elder law attorney. Why is an elder law attorney the person you want to go to when you're planning out the end of life for an elderly person? And how does an elder law attorney differ from a regular attorney?
Well, first of all, thank you again, Marcia, for having us. And there is a big difference between an elder law attorney and basically your typical estate attorney. When you're doing your estate planning, which is a very important part of what you need to be doing while you are alive, obviously, going to an estate attorney, they usually are focusing on legacy planning, which is what is going to happen to my money when I die. An elder law attorney is going to look at it in a little bit of a different perspective. We look at it as how can you plan right now to help preserve some of your assets in order to be able to qualify for some government benefits that you may not normally qualify for, but to be able to qualify for those government benefits so that you can protect your assets against the overwhelming cost of long-term care, so that in the end you do have money to leave as a legacy to your family members. So there is a whole different spin on the estate planning that we do versus what a typical estate lawyer would do. Again, estate lawyers are putting together a package or a plan that's going to help you leave a legacy, which is really a very important part, but it's not always the main part when you start talking about people who are in their 60s and early 70s. They need to do a different kind of planning, and that's what we do. We do different kinds of plannings to be able to protect those assets.
So you have different expertise. You've probably had different certifications in order to be able to provide this service.
Well, it's not different certifications, although I am board certified in elder law, which means I am a specialist. There's only about 107 board certified elder law attorneys in the whole state of Florida. It's a different spin on the estate planning. For example, what we normally put when we have a husband and wife into our estate plan is what's called a qualifying special needs trust. That's a special needs trust that can only be created between a husband and wife. And it's in the event that your husband or your wife is on government benefits at the time of your death and you have assets. And if you do your typical estate planning, which is that you transfer all your assets to your spouse, then if your spouse is already receiving government benefits, that transfer of assets could kick them off of government benefits. So what we do is we put into place what's called a qualifying special needs trust. It's a special needs trust, again, as I stated, that's created between a husband and wife. It allows the husband or the wife, as I like to tell them, to reach through the grave and still take care of your spouse, even though they might be sick. It puts a percentage of your assets into that special needs trust that is allowed to only be used for your sick spouse to better their care or better what's going on in their lives without affecting their government benefits. And again, there are other ways to get around this. A lot of estate planners will say, just cut your spouse out. However, as Phil can tell you also, because he does a lot of estate planning and probate, when you cut your spouse out, technically, and correct me if I'm wrong, Phil, they're entitled to 30% due to a spousal election. So
That's correct.
This way, we kind of protect that 30%. We protect that percentage, but we also leave assets available for the benefit of that sick spouse without affecting government benefits. So again, it's a different way.
Right. And when you say government benefits, you're talking about what?
I'm talking about it could be Medicaid benefits. It could be VA benefits. Medicaid does have an incredible long-term care program if somebody needs to go into a nursing home. It's called the ICP, or Institutionalized Care Program. If somebody has to go into a nursing home, that nursing home can cost anywhere from $8,000 to $10,000 a month. Medicaid,
or more, depending upon where you live.
Absolutely. Medicaid, and that's only for a shared room. That's not even for a private room or anything special. That's for a no-frills share room. Medicaid, if you are able to qualify for Medicaid, will pay for the entire cost of that nursing home minus that individual's income. And I'm not talking about a Medicaid nursing home. I'm talking about most of the nursing homes in the state of Florida. So if you have a spouse that is receiving that benefit because they're in a nursing home, and you have, the healthy spouse has $100,000 or $200,000 in their name, and they die with your typical estate that says, I'm leaving all my money to my spouse. Well, as soon as that healthy spouse dies, and unfortunately, as we all know, caregivers do tend to die before the ill spouse just because of the additional stress and aggravation that they live with, they are now kicking their sick spouse off of Medicaid, and it can cause a real problem. If you do the qualifying special needs trust, then again, they could put that money into a special needs trust that can only be created between husbands and wives. They can have their children be the trustee, and that money can still be used for the betterment of the sick spouse in that nursing home, to pay for maybe an aide, to pay for a private room. And then upon the death of the sick spouse, then the assets go to the children as the typical estate plan.
So it sounds like this is great planning to give a family peace of mind in the event of something happening to one spouse or the other, so they know exactly what's going to happen and not worry, and things are taken care of so that basically their plan is executed.
Exactly. And another thing, so if I'm dealing even with a husband and wife that are a little bit younger, Marcia, 60, 65 years old, there's other planning that we can also do. For example, a Medicaid Asset Protection Trust. If I do a Medicaid Asset Protection Trust for somebody who's 60, 65 years old, any money that they put into that trust will, after 5-year period of time, if they don't need care or they don't need to qualify for Medicaid, after 5 years, any money that's put into that particular trust will not count against them for purposes of qualifying for Medicaid. So there's also other planning that we can do. And again, it's the difference between an elder law attorney and an estate planning attorney. An estate planning attorney is not going to talk about a Medicaid Asset Protection Trust. Whereas an elder law attorney who's focused on, again, trying to protect as much of your assets as possible, to be there, to be able to pay for your care as you get older and unfortunately sicker, that's the type of planning that we're looking at.
Well, it makes sense because it sounds kind of confusing, the whole thing, to an ordinary person who's not in the legal field or perhaps the healthcare field. And it sounds very confusing, and I think that's the number one reason to seek out an elder law attorney to get the answers to some of these things.
Right. And if you don't do it properly or you don't do what needs to be done, then you end up with an attorney like Phil who does your probate stuff. So
yeah,
what I do is, I try to avoid doing the proper planning. We try to avoid probate. Of course, if you're doing a qualifying special needs trust, there is potential for a probate just because of the amount you're putting in there. But for the most part, our goal is to try to avoid having to go to an attorney like Phil.
Right, and that word...
Not that we don't love you, Phil.
Word, that's right. And that word probate, just that word, even though people don't maybe quite understand what it means, I think the word is scary to a lot of people. When they hear that word probate, it just conjures up all kinds of things that doesn't have to be scary if you planned ahead of time.
Well, let me say one thing, Marcia, real quick, because this seems to be a very big misconception on a lot of people. And, Phil, I think you see this too, is people believe if they just have a will that they are not going through probate. And that is not the case. Where there's a will, there's a probate. So the planning has to include more than just a will.
Right. There's not just where there's a will, there's a way, but where there's a will.
Where there's a will, there's a probate.
There's a probate. And we're going to talk about that when we come back. We're going to take our first commercial break and talk to Phil all about what that means, and we'll be right back, so stay with us.
Arden.
The inability to recognize the obvious often occurs with Alzheimer's, particularly among the family members who care for them. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to us. We know. We understand. We can help. Arden Courts. Wandering is a common problem for people with Alzheimer's or related dementias. It's also a problem for family members who care for them. Keeping them safe and secure means never letting your guard down. And even though deep down you know it's time, it hurts to have to ask for help. But it could hurt them even more if you didn't. We know. We understand. We can help. Arden Courts. Being unable to recognize the obvious often occurs with Alzheimer's or related dementias, even among their caregivers. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to Arden Courts. Memory care is all we do. We know. We understand. We can help. To learn more, visit arden-courts.com.
Info.
Arden Courts
if you have a
follows
question
equal housing.
or wish to share a story, call into the show at 565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
And we are back, and in the studio today I have my special guests, Heidi Freeman and Phil Rosen from Becker and Polikoff, PA. And we're talking about lots of things that caregivers need to know, including estate planning, what's the difference between that and elder law planning, and the dreaded word probate. And it's very exciting that you all are here. I'm actually broadcasting to you from Largo, Florida, near Tampa. And thank you for being in our radio station studio today in Boca Raton. And we're live, and thanks to the wonderful, amazing technology of internet and all those crazy things that I don't quite understand, we're able to see each other and communicate and make this show happen. So thank you again for being here, guys.
Thanks a lot. It's dry here, so we're just happy to be here.
It's dry. Let me tell you, it's raining cats and dogs over here near Tampa. So
yeah, it's been raining all day.
Yeah, trying to stay a little dry here. So we're talking about what caregivers need to know. Really, anybody needs to know, but especially caregivers, because they're dealing with a sick spouse, perhaps somebody that has Alzheimer's or some other form of dementia, and they need to plan because, as you mentioned earlier, Heidi, caregivers are under an overwhelming amount of stress. And this stress really causes them to maybe sometimes be not able to take care of their loved one. Maybe they're going to end up in the hospital first because of the sickness that stress can bring. They worry about, if I die first, what's going to happen to my loved one? How do I take care of them when I'm gone because there's nobody else to do it? So therefore, you come in as the elder law attorney on the white horse to save the day, to help them, plan for this. And I think, people need to know, I don't think there's enough said that pre-planning, we talk about pre-planning a lot of things, pre-planning your funeral and pre-planning the rest of your life and making sure you get to all the right resources so that you do have the best of the best so that you can do whatever you can do with what you have. And a lot of people say, well, I don't have that much money. Do I still need an elder law attorney? And your answer to that, Heidi, would be what?
Probably more importantly than somebody who has a lot of money. Pre-planning is so important. And the reality and the statistics show that approximately 2/3 of Americans will need long-term care at some point in their lives. It's just a statistic. What I'm seeing is people are getting diagnosed earlier and earlier, and we're living longer and longer. So the savings that we have, or what we think we're going to, live out our life with, are all of a sudden not lasting as long because the cost of care is increasing. So people in their 60s, really and truly like their early 60s, really, even if you've done estate planning, you need to then take that estate plan to an elder law attorney so you can change the focus of your estate planning. I can't say that enough. Estate planners look at legacy. What do you want to do when you die? Where do you want to leave your money? Elder law attorneys look at how can we make your assets last as long as possible in the event that you or your spouse get sick. And the earlier you plan, obviously, the more you can protect. We do crisis planning a lot, unfortunately. Even if I've talked to a client and told them the risks, sometimes they still, amazing to me, walk out of my office and think that that's not going to happen to me. And then, a year later, they're back in my office now doing crisis planning. So it is such an important part of what you need to have those conversations, and you need to do the pre-planning.
So
yes, absolutely.
The whole life cycle of planning, people think that you set it and forget it. And it's really when you're in your 20s and you may not have any kids, but you've got a little bit of money. So the first thing you do is say, well, who's going to make medical decisions for me? I'm single. And if I'm in a car accident, well, yeah, I would want my parents to make decisions for me. So that would be like the first step. Then people get married, and now the spouses want to be able to make decisions for themselves. Now, whatever money I have, I'd like to make sure it goes to my spouse. People start buying life insurance at that point, and then you start accumulating assets. So, when you're in your 20s and 30s, you may not have a lot of money, but you still need somebody to make decisions for you. Now, when you start to have children, then you start really getting nervous and thinking, okay, now what happens to the money? right? And so when we do planning, just from the basic standpoint, I ask my clients, well, would you like for your kid to get $1 million from your life insurance policy the day they turn 18? Or would you like maybe instead that money to be spread out over a period of time and say used for them, for their health, education, support, and maintenance, until they're 30, 35, 40? So there's all different things that we can do. But once you hit your 40s, that's when people have to really start thinking about long-term care. And, back in the day, you were able to buy a nice long-term care insurance policy. Mm-hmm. It was extremely affordable. And a policy like that would simply give you X amount of dollars a day for a set period or an infinite period of time. The problem with those policies is they're not offered anymore because the insurance companies did not anticipate people living as long as they live now, and they lost their shirts. I know it's very hard to feel bad for an insurance company, but we bear the brunt of it because now those policies don't really exist. So it's harder and harder for people to plan with just insurance products, and that's why attorneys like Heidi are becoming more and more important to people, because you can't just insure over this with a long-term care policy. You need to go to an attorney. And so now when people hit their 40s and their 50s, this is when they should be making these plans now and taking their estate plan to Heidi. And in that situation, Heidi can look at the plan and maybe augment that plan, help it, or rewrite a brand new plan depending on your family circumstances. There are people who say, look, my father was diagnosed with Alzheimer's at 61 years old. I'm 50. Do you think I should do some planning? And of course we say, well, yeah, this is the time. Heidi works in concert with estate planning attorneys as well to help them keep their clients happy, and Heidi will add the elder law component to that. So Heidi's not in competition with these attorneys. Quite the opposite. She can help them with their practice, and she'll work with them to help make sure that the plan they have in place now accounts for saving the money before the family has to spend it on care very quickly.
Well, thank you, Phil. That's a very good explanation, and thank you for sharing that because it can get very confusing. So your specialty in the firm is more estate planning and probate, is that correct?
Yes.
So explain how somebody comes to you and what would be the first thing that you would do. And we talked about trying to avoid the dreaded probate, because if you have the proper planning, and most times you can avoid that. And I do want to say something before we go on, that we are talking about the state of Florida here, because every state has different rules and regulations and laws when it comes to estate planning and probate and elder law and all of that. So if you're listening from somewhere outside of the state of Florida, just make a note that what we say here may not be applicable to you if you live in another state. But you want to go to an elder law attorney and to an estate attorney in your own state to find out those rules and regulations. So this is general information, but anything that we might say would be specifically to the state of Florida. Just wanted to clarify that for people listening.
So, in Florida, I have clients that come in, and people now are more educated than they were, 15 years ago. So they'll come in and they'll say, listen, here's what I need. I need a will. I want to avoid probate. And I say, well, okay, do you know what probate is? Well, they say, no, I just know I need to avoid it because that's what I read, or that's what I was talking to my friends about at the pool last week. So let's define probate first. Probate is the court's supervision of the marshaling and distribution of a deceased person's assets. That's all it is. Basically, in English, the court wants to make sure that you get all the assets of someone who passed away and then that you distribute them properly. That's it. It's pretty straightforward. Now, why is it something that people would like to avoid? Well, number one, it takes a lot of time to do. The average probate case takes somewhere between 9 months and a year from start to finish. In many probates, we have to have a personal representative, or people in other states would know the term executor. That person would have to be appointed. But sometimes it could take a month or 2 months before that personal representative is appointed. And from the time period that a person dies to when the personal representative is appointed, everything is in limbo. meaning you can't do anything. You can't access bank accounts. You can't make any decisions. You can't sell a property. You can't do anything. So you're frozen in time. And think about a situation that I had many years ago where a husband had all of his assets in his own name. His wife wasn't on anything. They had 2 young children and a house where, unbeknownst to the wife, he hadn't paid the mortgage in a year. So you have a woman who has, husband just passed away unexpectedly. She has no money, and she has a house that's being foreclosed on. So in that situation, I had to run to court and try to have a probate opened on an emergency basis, stop the foreclosure from happening, et cetera, et cetera. So it's a very stressful time period. So why do we want to avoid probate? A, it's because of the time involved. B, I don't think it's a problem. Most people do, is that the typical probate fee set by Florida statute is 3% of the value of the assets in the estate. That's a nice fee for a lot of work, but nevertheless, it's still a lot of money that you could avoid having to pay if you have your planning done. So,
And who gets that 3%, Phil?
me.
The attorney.
Okay.
Yeah, the attorney gets that. And the personal representative also gets 3%.
Yeah, right. The personal representative gets a fee as well.
So,
Okay, so there's a 3% to the personal representative, a 3% to the attorney. The state, the actual state, is not involved in getting any kind of the assets.
No. The state of Florida doesn't have an estate tax. So people don't have to worry about the state coming in and taking their money. On the federal level, you have to have over $5 million. And if you're married, over 10. For everybody out there who has that problem, good for you. Okay?
It's a good problem to have, maybe, right?
Right.
Yeah,
If you have to
exactly.
pay estate taxes on that, it's okay.
Yeah. So let's talk about how do we avoid probate. A very simple way to avoid probate is to take your assets and put them into what people commonly know as a revocable living trust. A revocable living trust, if you think of it as a red wagon, you take all of your stuff, you put it in the wagon, and you go through life holding up the handle to the wagon and just dragging it along. Anything you want to do with your assets, you can do with your assets. But the only difference is when you die and that handle falls, instead of having to go to court, your successor trustee, that's the person who's in charge of the trust, comes along, picks up the handle, opens up your trust, which is their instruction booklet, and it tells them how you want your assets split. It tells them exactly what needs to be done. And you do this instead of in a courtroom, you could do this in your living room or in your lawyer's office with your lawyer telling you exactly how things need to be done. It's really that straightforward and simple. However, that planning is only good up to a point because really that planning is just talking about your stuff. When it comes to Heidi and what she does, she's not talking about just your stuff. She's talking about how are we taking care of somebody and then using your stuff, your money, to take care of you to stretch your money as long as possible so that you get excellent care.
Okay, that's very good. And I love your analogy of the little red wagon and the handle falling off and someone picking it up. And I pictured that while you were explaining it, and I love analogies, so thank you for painting that picture for us. I have a lot more questions for you regarding probate and these revocable living trusts, and I'm going to ask that from you as soon as we come back from commercial break. So we'll be right back.
Do you need the
Wandering is a common problem for people with Alzheimer's or related dementias. It's also a problem for family members who care for them. Keeping them safe and secure means never letting your guard down. And even though deep down you know it's time, it hurts to have to ask for help. But it could hurt them even more if you didn't. We know. We understand. We can help. Arden Courts. The inability to recognize the obvious often occurs with Alzheimer's, particularly among the family members who care for them. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to us. We know. We understand. We can help. Arden Courts. Somewhere at the corner of bewildered and confused is a lost mother, a father, a sibling, a grandparent. Wandering is a common symptom of Alzheimer's or related dementias and can often make those who care for a loved one feel just as lost. If you're looking for a place that's safe and secure, look to Arden Courts. Memory care is all we do. We know, we understand, we can help. To learn more, visit arden-courts.com. Arden Courts.
Dr. Teal, an Alzheimer's disease and dementia care expert on CareGiverSolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
And we're back with more Caregiver Solutions. I'd like to take this opportunity right now to thank our national sponsor, Arden Courts Memory Care Community. Arden Courts has over 50 communities across the United States. So they have 10 actually right here in Florida, and the rest scattered across the United States, and hopefully one near you. Arden Courts cares about not only the resident, because memory care is all they do, but also about the caregiver. They have all kinds of resources for caregivers, and one of them they'd like to offer to you free today. This is called the 36-Hour Day Book. This book is phenomenal as far as helping caregivers to understand different kinds of dementia. It actually explains to the caregivers tips and behaviors that can happen along the way, along your journey, in your caregiving journey. It's written by Dr. Peter Rabins and Nancy Mace, and it's in its 5th edition. And I can't recommend this book enough. If you're looking for some written resources, this is a great book to have on your shelf, to grab it whenever you have a question, you want to learn more about caregiving and Alzheimer's and dementia in general. To get this book, all you have to do is call the toll-free number of Arden Courts. Tell them that you heard about the offer on the Caregiver Solutions Info radio internet program, and they all will send the book to you by just getting your name and your address. So jot down this number because you'll want to call them as soon as you can, and that number is 888-478-2410. Again, 888-478-2410 to get your free book called The 36-Hour Day. I highly recommend it. So I'm back with my guest. They're joining me via internet magic. I'm in Largo, Florida, where we have an Arden Courts Memory Care Community near Tampa, and my guests are in the radio station studio in Boca Raton. And I'm with Heidi Friedman and Phil Rosen, and they're from the law firm of Becker and Polikoff, and we're talking about all things estate planning and elder law planning and things that a caregiver should know so that they can actually make things easier and a little bit better down the road for when they're caring for someone. Actually, it's great for anybody, but we really try to explain to caregivers, don't wait, don't procrastinate. We just heard Phil mention that, someone comes in and they're in a crisis and maybe they thought about it, but they never really followed through, and now they're in a crisis and it causes a lot more stress and very overwhelming for caregivers. So I want to go back to you, Phil. We were talking about how to avoid probate because probate is very expensive and probate also is very time-consuming. So I have some questions for you, and I hope that caregivers are listening very carefully because this is actually good stuff. And, a lot of attorneys would charge you a lot of money just by asking the questions that I'm asking of you, and it's right here at their, not their fingertips, but right there for their ears to hear and their eyes to see if they're joining us via the internet. So, Phil, back to you.
So wait, Marcia, I'm not being paid for this?
Yeah, we'll talk about the benefits later. Actually, I really do love you guys because I've worked with Heidi a lot, and she's so gracious with giving her time and her expertise to talking to caregivers and doing a consultation just so that they could see, is this the right thing for me to do? Am I on the right path? And if I'm not, Heidi's going to actually tell you, maybe you need to see somebody like Phil, or maybe you need, some other type of legal advice. But this is the greatest thing about having resources that you can know and trust and go to say, hey, I heard about you. I saw you on CareGiver Solutions. Marcia Teal recommended I call you. Can you help me? And you're, open arms to say, what's your situation? Let's, give me an idea what's going on. And, if we can help, then we'll go forward. And thank you for that, by the way. So, Bill, I want to ask you a question. Again, we're talking about revocable living trust. And when we say revocable, that means what?
That means that you can, quote, revoke the trust at any point. From a practical standpoint, it means you can do with the assets in the trust whatever you want to do. You can take the money that's in your account, you can buy a new car, you can gift it away, you can gift your money away to people, you can do planning with Heidi, you can do anything with your assets that are in the trust that you would do if they were not in the trust. That is a big distinction from an irrevocable trust, which really at this point in time people use for two reasons. One, to avoid estate taxes, which we're not going to talk about today. But two, it's for pre-planning for somebody who's concerned that they want to save their assets to be used for them in the event that they need additional care, and that's what Heidi does. So there's a big distinction. Revocable, you can do anything you want, and you can also change your trust. This happens very often. People will do a trust. They'll call me 2 years later and say, Phil, here's what happened. One of my kids, he makes a tremendous amount of money, and my other child doesn't really make much. I'd like to change the distribution so that I give the child who makes less money more money. It'll make me feel better. And then there are some people who consistently change their trust, and it works for them. As opposed to the people who set it and forget it. But you'd always like to have that option. So that's probably one of the biggest points, is that you can change the trust in any aspect.
Okay, and that gives you flexibility to do lots of things. And your life situation can happen, but if it was irrevocable, you wouldn't have that flexibility, basically.
That's true.
Or
And
it wouldn't be as easy.
Also, one thing people need to understand is that when it's a revocable trust, those assets are still considered yours. They're under your Social Security number. If you open up a bank account under your revocable trust, it's under your Social Security. When you do an irrevocable trust, the assets are technically no longer yours, but now belong to the trust. You need to do a new tax ID number for that irrevocable trust, and it has its own, tax accounting and things like that. And it's actually taxed at a much different rate than an individual or a revocable trust. So that's another thing that you really should know about the difference between an irrevocable and a revocable. I get this a lot. Irrevocable trusts, again, are used for pre-planning in the Medicaid aspect. We can use a Medicaid Asset Protection Trust, which is an irrevocable trust. We use it also in the VA planning, doing a Veterans Asset Protection Trust in order to transfer assets from a veteran and to qualify them for another known government benefit called aid and attendance. But people have to understand, once they do transfer over to an irrevocable trust, it's very difficult to change those instructions once you've made them.
Very, very good point. Thank you. I just came across a situation very recently talking about probate, Phil. There was a woman, and her husband died, and I don't know all the details, but I think the point is the wife, or who's the mother, and I'm talking about a son and his mom. The mom has dementia, and she's living up north in another state, and the assets are all going through probate right now. The problem is the mother has dementia, and the son, who lives in Florida, wants to bring her down to live at Arden Courts, but right now he has no access to the funds to be able to bring her down and pay for her care. So the money's tied up. She's got dementia. They're trying to deal with the situation at home and, help the woman to, live there without having the expert care of a community like Arden Courts. And they're struggling. And the son just told me the other day that he's already been I think he said 4 months into this. He's starting to see the light of day, but he was so overwhelmed, so frustrated, so angry about everything. I just felt so bad for him. And so this is, again, a typical case that you probably see a lot, right?
That's an all too common occurrence. And, you can't help but be angry if you're the son, to be somewhat angry and disappointed with your parents, because this is something that probably could have been avoided. But, every situation is different. And any bit of pre-planning that you do is better than nothing at all. Once you're in the probate process, you can do things on an emergency basis, but there are certain formalities that you cannot avoid at all. And it's a long haul for the son. And you know what? 4 months into the process is, depending on the state, may not be that far. I do a lot of work with attorneys in other states, especially in the Northeast. And the probate process there is even slower than it is in Florida. And so, I sympathize with him, because he's going to have to wait until he can get the money for her. And I don't know what they're going to do, because if she's got dementia, he may have to have a guardian appointed. He may have to have himself appointed as guardian for her to handle the funds. In that case, though, now the court has to supervise the money that's being used for her care. And it's difficult to do the type of planning that Heidi's talking about, because now you have an added layer of scrutiny from the courts, an added layer of costs, and it definitely takes a lot more time to get things done. So the lesson to everybody out there is that plan when you can, and which is now. So any time that you can plan is better than waiting for someone to get really sick or to pass away and then leave money to a spouse who is sick already.
Right. In that particular situation, Marcia, if the parents had done the proper pre-planning, first of all, Phil's right, they might not be sitting in this situation. The son wouldn't be sitting in this situation. But also, most likely, there would have been a durable power of attorney that probably would have been executed, making the son the financial agent for the mother as well. So the fact that she's incompetent at this point wouldn't play so much of a role as it will now if they didn't have that document. A durable power of attorney, I know we've talked about this on many other shows, is one of the most important documents that anybody over the age of 18 should have, as well as a healthcare surrogate and living will. But with a durable power of attorney, that would avoid at least that guardianship process that is so painful to go through, and also time-consuming and expensive.
Mm-hmm. Mm-hmm. Yeah, very, very good point. Well, we're going to take our last commercial break, and when we come back, we're going to hear more from Heidi Freeman and Phil Rosen, the wonderful attorneys that are with us today. So stay tuned, and we will be right back.
Arden Courts is not just
Wandering is a common problem for people with Alzheimer's or related dementias. It's also a problem for family members who care for them. Keeping them safe and secure means never letting your guard down. And even though deep down you know it's time, it hurts to have to ask for help. But it could hurt them even more if you didn't. We know. We understand. We can help. Arden Courts. The inability to recognize the obvious often occurs with Alzheimer's, particularly among the family members who care for them. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to us. We know. We understand. We can help. Arden Courts. Feelings of depression, isolation, and frustration are common among persons living with Alzheimer's or related dementias. It's common among those who care for them, too. It takes a lot of patience and courage. It also takes knowing when you can no longer do it alone. At Arden Courts, memory care is all we do. Talk to us. We know. We understand. We can help. Don't let guilt keep you from making the right decision. Visit arden-courts.com. Arden Courts follows equal housing.
.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
Hi, and we are back with attorneys Heidi Freeman and Phil Rosen from the law firm Becker and Polikoff, and we're talking about lots of things legal. And Heidi, right before break, you mentioned about durable power of attorney to avoid maybe somebody having to do guardianship, which leads me to the next segment that I want to talk about before we have to close the show in a little bit, about the legal documents that people should have no matter who they are, what age they are, or what circumstance they're in. Can we discuss that?
Sure.
So besides power of attorney, what else?
I do want to say one thing before we get into those documents, if this is okay. One of the things that we find, and that what tends to happen, that people are advised to make their children joint owners on their bank accounts in order to avoid probate. I'm going to tell you, and I don't know how Phil feels, but I really believe that that's a big mistake. And one of the reasons why is what people don't understand is when you make your child a joint owner of your account, you've now opened up your money to their liabilities, whether they, God forbid, get into a car accident, a divorce, a creditor. So you're much better off getting a power of attorney that appoints them as an agent and making them the power of attorney on that bank account as opposed to joint ownership. And also then making a beneficiary on that account so that upon your death, it will still fall to them. So instead of actually putting your children on your bank account, you kind of almost put them around your bank account. You make them as an agent in order to help you make decisions or be able to act for you while you're alive, and you make them as beneficiaries. So upon your death, those monies will fall to them without going through probate.
So I'll add to that. The next step, the next layer there is if you have a revocable trust prepared for you, all of your accounts should be titled in the name of the revocable trust so that if something were to happen to you, not just if you would pass away, but if you're sick and you can't make decisions, you can't do things for yourself, your trustee comes in, picks up that handle once again to your wagon and can immediately take over and do whatever needs to be done so that you don't have to worry about anything. Now, one other added layer there is that with the revocable trust, maybe you have a situation where, again, you've decided that maybe you don't want one particular child to get money. Maybe they're having legal problems. Maybe they're getting divorced. So you can go in and amend your trust as opposed to having to go to the bank. That makes life a lot easier to, again, make those changes just in your lawyer's office, and they don't take that much time or effort to do it all.
Now, one asset that cannot be transferred into your irrevocable trust is your IRAs or your qualified money. Those assets have to be in your own personal. You mean
retirement accounts?
Retirement accounts. Yes, thank you
Yes.
for qualifying that. So that's also a reason why, even if you have a revocable trust, why it's so important to still have that durable power of attorney. And one other thing, Marcia, a lot of people don't understand just because you're married does not mean that your spouse can automatically act on your assets. You still have to appoint them as an agent unless you are joint owners. So I get that a lot. Well, what do you mean? We're married. Why can't my husband deal with my IRA? He can't unless you have that durable power of attorney. So that's a really important document. If you're going to ask what other documents are really important, it's your healthcare surrogate and your living will. Right now, your healthcare surrogate is somebody that you choose to make healthcare decisions for you, whether you're capacitated or incapacitated. That's a new portion of the statute that basically says if you initial a certain section, then your healthcare surrogate can actually make decisions for you while you're still capacitated. Of course, you always have to be involved in the decision, and your decisions overrule if you're capacitated, but it does allow them to speak to your doctors. It allows them to avoid HIPAA. It allows them to actually look at your records. A second piece of that healthcare surrogate is the person that you choose that in the event you are no longer capacitated, but you're not terminal, you're not dying, maybe perhaps you have a really bad flu or you've had a stroke, something that's made you maybe a little bit more delusional and you're not able to talk to your doctors, your healthcare surrogate can step in. But the most important piece is the living will. And that's the portion of the document where it specifically tells your surrogates, what do you want to have happen in the event that you are terminal, that you have, you're no longer probability of survival, that you're living in a coma or you're brain dead, or you no longer recognize the persons and places around you. If you do or do not want life-prolonging procedures. And a lot of people automatically think of a living will and say, oh, well, that just means I want the plug pulled upon my death, but that's not always necessarily true. It can also say the other part. You can say, I don't want the plug pulled. I want to be frozen or live whatever I can live. Or it can be as specific as you want it. I don't want I don't want to die unless, my heart rate is at a certain. I had a woman actually be that specific in one of her healthcare directives. So a living will is very important to let your surrogates know what you want to have happen.
Yeah, that's important because I've had situations where people say, I don't know what my mom wanted. And my sister and my brother and I, we all disagree, and now we're in a big family fight because everybody wants something different, and it gets real messy.
The whole goal of planning is, when somebody gets sick or somebody dies, it's an emotional family situation. And your family can either come out of it unscathed if you've set it up properly and you've made those decisions, or you can create incredible dissension within the family, depending on if you haven't planned. And now everybody's got different opinions of what they want to have happen. I've seen it myself where my own aunt was on, life support, and two of her children wanted her to go ahead and die because they had told her that, and two of her children were like, no, adamant, and they found a healthcare surrogate. They found a living will that she had put into place, so it was able to take that decision away from the children that my aunt had actually made it herself. And now there's no guilt and there's no fighting between them because she's already made the decision. So it is a really important document.
Right. And, I just came across another situation at perfect timing because I have a wife and a husband been married 33 years. The husband now has dementia. There is no durable power of attorney in place, no health care in place, no living will in place. Now there's a daughter from a previous marriage. The husband's daughter lives out in Nevada, and she's in denial that anything's wrong with her father, that he doesn't really have dementia, and she doesn't trust the wife to take care of him. And if the wife wants to put him in a memory care for his dementia, the daughter is contesting it, wants to come to Florida to kidnap him, to take him back to Nevada with her. And the wife has really no legal authority because she's not the responsible party other than just being the wife. So it's creating a lot of ugly family dynamic messes here.
Marcia, there's one other document that we didn't mention, and that's a pre-need guardianship document. And what that document says, it's very simple. It says if I get to the point where it's appropriate for somebody to be appointed as my guardian, here's who I would like to be appointed. Now, if he had left a document like that stating that he wants his wife to be appointed as his guardian, she could hire an attorney and move to be appointed as his guardian. And if the court found that he was, in fact, incompetent and needed a guardian, she would be able to be responsible for him. She would dictate where he went, and the daughter would not be able to take him away from probably the only things that give him comfort, or knowing where his home is and still recognizing his wife, hopefully.
And now in the situation that they're in, without that pre-need guardian, even if the wife does file a guardianship, the daughter has every right to know that guardianship is being filed and can hire an attorney and go ahead and contest it. And now it becomes a big, ugly fight between the wife and the guardian. The wife and the daughter of who becomes the guardian. And sometimes the courts will throw their hands up and say, you know what, we're just going to bring a professional guardian here.
And then everybody kind of loses. So before we have to close today, I want to give you both an opportunity to tell everybody how they can contact you, because I'm sure that they would want to follow up and maybe have questions and maybe want to make an appointment with you. So tell us where you're located and give a phone number, the best way for someone, for either of you, both of you, and let everybody know. So go ahead and do that.
Sure. Thanks so much. You can call me. My direct line in my office is 954-364-6026. It's 954-364-6026. That's always the best way to get me.
And my direct number is 954-364-6021. 954-364-6021. And again, best way to get me.
Great. And I know that your firm has offices in other parts of Florida, and we actually have Arden Courts in the same cities as your firm. I know you have an office in Naples. You have one in Tampa. We have an Arden Courts in Naples. We have an Arden Courts in Tampa. So I think this is a real good partnership where if caregivers are listening and they they know and they trust Arden Courts, they can contact your firm in the locations that are nearby them and maybe follow up that way. Also, if they're not here in South Florida where we are.
Certainly. We welcome you also to look at our website. It's got a lot of great information. It's www.bplegal.com. That's BP for Becker Polyakov.
And we can help assist, and we can assist people in all parts of the state of Florida.
Very, very good. Well, it's so important. I want to thank you both for coming today and being with us and sharing all this awesome information. Very important. My takeaway is don't wait. Do it now. And as you've actually endorsed that, and I hope you come back at a later date and we'll do some more talking about this important topic.
Well, thanks for having us. We appreciate it.
Thank you, Marcia.
You're very welcome, and thank you all for tuning in and listening to the show today. And we will be back same time, same place next week. In the meantime, don't forget, give somebody a hug because they need it, and so do you. We'll see you next time.
Give me a hug.
Thanks for joining us for this week's Caregiver Solutions with Marcia Teal. Join us next week as Marcia, who has 15 years of Alzheimer's disease and dementia care experience, brings you more needed information to help with the care of your loved one. This show can be seen again on caregiversolutions.info, and questions can be left on the site, which may be used on the program to help others. See you next week for more.